order. Good morning, colleagues, and good morning to our witnesses for this, our session on our legacy inquiry. On behalf of the committee, to our witnesses, you are very welcome and thank you for joining us. Just before I ask our witnesses to introduce themselves and to make any opening remarks, I'm sure the committee and indeed our witnesses will join me in sending our thoughts, prayers and condolences to the friends and families of Noah Donohoe, who passed away this weekend, and our thoughts and prayers are obviously with him and for him. Thank you. Right, may I ask please our witnesses to introduce themselves and make any opening comments which they wish to do. Who's going first? Am I looking to Kathy? Let's go with you first, please.
Good morning, committee, and thank you, Chair, for inviting us along to give evidence this morning. My name is Kathy Curran. I am one of the Advocacy Support Officers at Wave Trauma Centre. I've been with Wave for 4 years now, and it's been a real insight into working in legacy and a privilege working with families and victims and survivors. And I hope that the insight we can give you today will be helpful in your inquiry.
Thank you. Sandra.
Hello, Chair. On behalf of Wave, thank you for inviting us to come today. I'm Sandra Peake, the CEO of Wave Trauma Centre. I've worked with victims and survivors for 25 years, and I suppose we have seen successive consultation reports and initiatives through that time in dealing with the past. And we're delighted to come to present to you today and to share a little bit about our thoughts and our work in relation to victims and survivors.
Thank you. Reverend Clemens.
David Clements, thank you, Chair, for the invitation. I am a Methodist minister working in Carrickfergus, although the Methodists in Ireland, we move around fairly frequently, so I have worked in various places, including the Shankill, where I was at the time of the Shankill bomb. And about that time in the early mid-90s, I got an invitation to go to Wave, and I met the women who were a remarkable bunch of people. And shortly after that was invited to join their board, and I've been there ever since. I did a deal with Sandra Peake 25 years ago or so, and I promised I would stay on the board as long as she stayed in her role. And we both, well, we're both still here. It may be helpful to the committee just to know as well that I wear other hats, and as a Methodist minister, I chair our Council on Social Responsibility. And you will have had a submission from us, and just for clarity, some of you may have read, I'm sure you've read all of the papers. So I am the same David Clements as is in the Methodist paper.
Thank you. Good. Sandra, did you want to say opening remarks, or do you want to go straight into questions?
Thank you, Chair. I'm happy to say a few opening remarks.
Thank you. The floor is yours.
Okay, thank you, Chair. I suppose in relation to Wave, we've been deeply concerned by the new direction of travel in relation to addressing the legacy of the past. We have made our submission to you, and that details it more fully. But I suppose if I can summarise in 5 points, that we're concerned about the lack of clear information beyond the written ministerial statement. And it's very difficult to be able to comment in relation to full legacy processes when you have literally two pages in front of you. And I suppose we would have much preferred to have seen a much more fuller consultation process, and no doubt you will touch on that. Because we think that really garners mistrust at the start and really undermines any goodwill. We want to see a process that's independent, it's fair, and that it builds trust and confidence, and that is crucial for victims and survivors. I mean, I've worked with Wave from '95. I sat through the Bloomfield report, where victims and survivors, one of the key issues was a process to deal with the past. We engaged with the Eames-Bradley report in 2009. A key issue out of that was the need to deal with the past and the process. And we engaged with Haas O'Sullivan and Stormont House. And I suppose our concern each time has been that victims and survivors have been built up for processes that have not delivered, and that we really want a process that's fair, that's impartial, and that does deliver. And I suppose we're very concerned in relation. We thought we had that through Stormont House, and we're concerned now in relation to what's before us. The families of the bereaved need acknowledgement, and they need a thorough and full investigation. It needs to be fully Article 2 compliant, and we're concerned that if that's not the case, and all that we're doing, Chair, is transferring the trauma to the next generation. And we've seen that in WAVE. We now deal, I used to deal with parents, you're now dealing with siblings, and you can see that it's the next generation of grandchildren that are coming forward. So that's a very, very big issue, and it's an issue as a community and society we need to take aboard. We have grave concerns about proposals to close cases, and we'd like to talk to you about that. And we think that's an affront to the dignity of families. And, you know, the very final point that there is an emphasis in relation to reconciliation, and we're concerned that this will be far from reconciling, and that actually it could be more damaging in relation to community relations, and also that it could signal to dissident and to loyalist Republican paramilitaries that, you know, you will not be held to account, and that if there's a failure to deal with the past, that will continue. And that's something which is very, very important in relation to how we move forward. So we're an organisation that essentially works as a very strong service provider, and in the last year we had over 900 new referrals from the ages of 4 to 98 in that age spectrum. We provide services to over 3,000 people per year. And I suppose what I want the committee to know is that this is far from diminishing. Need is very much present, and victims and survivors are very much present within our community and are presenting today for services, some for the first time, decades after their loss.
Thank you very much indeed for those remarks. Could I just ask you to give us your thoughts with regards to the current situation stroke impasse with regards to victims' pensions?
Well, we're very disappointed in relation to the current impasse on a victim's pension. We, for 10 years, have a very active and dynamic injured group who have driven this pension chair. They've had many bumps along the way in relation to hoping to see progress. We were delighted that when legislation then was eventually granted, that it would come in speedily. We were very concerned when we saw that there was inaction on behalf of the Executive Office, and we raised that. We wrote to the First and Deputy First Minister in April. We have yet to receive a response to that letter. We have continued to highlight at every opportunity that this is morally wrong to deprive people now of an injured pension. And I think it shows the difficulties that exist in Northern Ireland in relation to something which should be a good news story, something which should deliver for people, and something which should deliver to our most vulnerable individuals. And we would want to see concrete progress made in relation to getting a department nominated and to getting the victim payment scheme well underway. I mean, that should happen.
Thank you. This hopefully may be answerable in a yes, with a yes or a no, which is, as far as you're concerned, with regards to the definition of victim, are you happy? Yes or no?
Yes, we're happy with the current definition.
Thank you very much indeed. That is very helpful.
Can I add something to that, Chair? Do you mind?
No, of course, with the greatest pleasure.
Because I think that fundamentally the issue about definition is about access to services. There should be no bar to service provision for people to receive psychological services, you know, physiotherapy services. That should be in place for families, and therefore, I mean, that is. I trained as a nurse. I worked as a nurse. We served everybody, and in the same way, I think the definition needs to be there for service provision.
Thank you. I think that's a point well made. Mr. Paisley.
Thank you, Mr. Chairman. And at the outset, can I say to Sandra, Kathy, and David, huge public thank you for the very hard work that you actually do in addressing this issue and in keeping it very much in the public mind. I know it's incredibly difficult work and at times traumatic, but it is important to place on record publicly a huge thank you to you. Sandra, in your opening comments, you mentioned about your paper, which committee members have seen, and you actually very succinctly outlined the 5 key objections to where the failings in the current arrangements for dealing with Northern Ireland's past actually stand. So I won't ask you to go over that because you've actually saved a huge chunk of the first question by being so succinct. Could I ask you a little bit deeper in that? What would acknowledgement look like? How would we address that issue of acknowledgement? And secondly, how would we address the issue of reconciliation? I'll leave the reconciliation one to the end. If we could deal with acknowledgement first.
I mean, I think there's been a huge issue in relation to acknowledgement, where people feel that they have been overlooked, and that the pain and suffering that they have endured has not been recognised. And I suppose in relation to the proposals put before us, for many people, it's to know their loved one mattered, that they mattered, they had value, and that there should be a full investigation into what happened to them. They should know as much information as possible. And you know, for many people that simply hasn't happened. I mean, it hasn't happened because just of the state, I suppose, and you know, the ramifications of the Troubles. But for many people, they didn't get that. And I suppose, I mean, we would very much endorse the work of Operation Canova. We have seen the value for families who had never had anything, maybe even never had the police to their door to tell them their loved one was dead. For them, in relation to being able to go through a full investigation and to hear and to get information is so important, and to know that somebody is looking at that impartially, fairly, and will come to them with answers, and that their loved one, you know, and that they have the credibility to do so. So for many people, and for many victims and survivors today, it is about us acknowledging, having a full record, and putting on record. I mean, if you remember back to Lost Lives, when Lost Lives come out, there were huge issues for people in relation to the details that were in that they felt didn't reflect. They didn't reflect what happened to them. And that book went into every library in Northern Ireland. It went into every school in Northern Ireland. So for many people, it's about ensuring that the facts are there, that they're down, that they're available, and that we as a society don't overlook what people have come through, and that we provide the very best services to them to meet their needs. But fundamentally,
and Sandra, whenever you hear that from some people that in terms of acknowledgement and in terms of investigations which can no longer take place because the words that are used, there's no likelihood of a successful prosecution or a successful outcome, how do you address that issue whenever some of your members are told, look, there's never a likelihood that this would come to an end? How do you address that subject?
I'm not so sure how many people, I mean, we deal with many people and about their expectations of prosecution. Yes, some people would like prosecutions, and there's even variations within families around that. But for many people, it's actually the investigative process. It's actually knowing that somebody has looked at the facts around their loved one's case from the start to the end, and that every effort has been made to give a full and frank account of what happened to their loved one. And for many people, they simply haven't had that. They haven't had that process. And I think that in that process, there is a very clear form of acknowledgement. I mean, we put in place when Operation Canova started, we put in place, you know, in terms of how families, in the evaluation process, how families felt, did they feel, where was their trust and confidence? What did they believe they were going to get from this process? And what they've seen from that process is respect, frankness and openness, and a sense that their loved ones mattered, and their loved ones their deaths deserve to be fully looked at. So I think that that's something which is very, very important. Can I refer maybe to my colleague Kathy, who has worked in relation to, from an advocacy perspective, day and daily with families, to add to that?
Thank you. Kathy Curran?
Yes, absolutely. I mean, I would agree with everything that Sandra has said. Acknowledgement takes many forms, but really it's about treating people with dignity and respect. And unfortunately, throughout the Troubles, there have been so many experiences where there's been a real vacuum in terms of dignity and respect. Families haven't been afforded the opportunity to sit down with police and talk about what investigation did take place. They don't have information around how their loved one died, what the circumstances were. And then they've gone through processes which have been fruitless, which has simply compounded their grief and compounded their sense that they don't matter or that their loved ones don't matter. For example, going through an HET process for a family whose loved one may have been killed under the auspices of being, let's say, an informer. And they're very keen to know more about that and never really being given that information. And that has been held behind a firewall of we can neither confirm nor deny. which isn't good enough for families, and certainly not in this day and age. So I think it's really important that people are given as much information as possible, because it's empowering for them, and it also enables them to make progress. There's a lot of talk and a lot of use of the word closure, which I personally don't agree with. And it's easy for me to say I'm not a victim and survivor, but at the same time, you can't close the chapter, you can't close the book on this. It's a part of our society, and it's a part of people's family histories and community histories now. It's about transformation more than anything. And the only way you can really help people transform on an individual level, on family level, or at a community level is by empowering them, by giving them information, by treating them with respect and dignity. And for me, that's what acknowledgement looks like. And that means that a full and thorough process needs to be followed.
Kathy, that's missing in the current process, you believe? Your presentation makes that clear, that part's missing. If that was factored in, and it's not just an easy thing to factor in, it would be very complex, but if it's factored in, would that help resolve some of the issues and make the process much more manageable for victims, do you think?
Absolutely. I mean, from my observations and my experience over the past 4 years of working with victims and survivors and families, it's not an outcomes-driven process. The process is the outcome in itself. The ability to walk with the investigators, to have communication with them, to have access, in the case of Operation Canova, right to the top of the tree. John Boucher has made himself accessible to every family, and that is a huge gesture to make when you are talking about families who didn't even have a phone call or a knock at the door let them know somebody had been killed. So it's really about, that's a process of healing. It's a process of doing.
That potentially could be lost under this new process. Isn't that a fear?
Well, that is a huge fear. The new process, for all intents and purposes, looks like a desktop review, and there's no depth to that, unfortunately. And if you're just going to take information and make a review based on what was already there, without sort of drilling deeper into information and accessing information and records in other places, you're not going to get a different outcome for families. And repeating the failures of the past, I don't see how that helps any of us to progress in the future.
Okay.
Thank you.
Mr. Chairman, I think actually most of those comments cover the issue of reconciliation, unless David had something to add.
Yes, okay. Thank you, Ian. I appreciate the question, and it's a very important one, and it's a difficult one to answer. Sandra and Kathy have answered it well. I would add one thing, and it may be helpful for the committee just to know where the name WAVE came from. When I first met this bunch of women I mentioned in just after the Shankill bomb, they had been meeting for a couple of years because there was no other support group for victims. They were started by Sister Marie McNeice, a Catholic sister, and they invited me as a Protestant minister to be part of their group, which I was very glad to do. Originally, it stood for Widows Against Violence Empower. That's where the WAVE came from. There was always little brackets, widows, brackets, widowers, so they didn't discriminate against men who'd lost a partner. But over time, it became a much broader organization involving people who'd lost parents or children or siblings, or people who've been injured or affected by the Troubles in all kinds of other ways. And we struggled for a long time to find another acronym that would fit WAVE, and we couldn't. So we just kept the name WAVE because it was well known by then, and called it the WAVE Trauma Center. But that key word at the end of that, the E, empowerment, was always a crucial issue. These were a bunch of women who'd lost their husbands in different circumstances by loyalists and Republican paramilitaries, all of them. But they were finding a voice. And I think that if there's one thing that I think helps to understand what acknowledgement means, it's to be able to have your voice and to be heard. The issue of investigation and prosecution and all of that is very difficult, and it may never happen. And I think probably holding out a false hope of a prosecution and a conviction at the end of it to victims can be a cruel thing, because if it's very, very unlikely to happen, it seems to me you've got to find other ways for them to have their voice heard and other ways for them to be empowered. and to give them some role in that, and not just treat them like a political football where they're kicked this side and then kicked the other side. And I think that's been one of the problems over the last 2 decades in particular, since the Good Friday Agreement. The issue of legacy and victims and their part in that has been very difficult and is contested. And if we can find a way of giving people their voice, empowering them, acknowledging their loss, acknowledging that what happened to them was wrong, that's the crucial issue. My dad was a policeman. He was shot dead by the IRA in 1985. I've had lots of conversations with Sinn Féin and Republicans and others. I think they're useful exchanges. I mean, I'm able to do that. Lots of other people aren't. I mean, my mother would never engage with them, for example, even when she was younger and fitter. But I mean, I'm articulate enough to be able to engage in that, but there are lots of others who aren't. And my concern is that this process will just sort of sweep the issue under the carpet for another 5-10 years. And the bump on the carpet's not going to go away.
Thank you.
Thank you. Okay. Can I just remind us, we've got until 10:30 for this, or just before 10:30. So I do want us to cover as much territory as possible, and I don't want to be terribly strong on the whip hand on that. So I'm going to go to Robert Goodwill, who is well known as a man of terse Yorkshire words.
Thank you, Mr. Chairman. David, we've just been hearing about empowerment and having your voice heard, and indeed, when Sandra made her opening remarks, she talked about her concern about the new direction of travel, and this sort of 2-page ministerial statement was, I think, probably a bit of a bolt out of the blue. So could I ask, maybe starting with Sandra, do victims feel that they have been listened to and engaged with during the development of this new legacy framework? And when I talk about engagement, are we talking about the engagement with the organisations like yours, or with people more generally who may wish to engage? I think Sandra, if you may.
Thank you. Well, it did come like a bolt out of the blue, and I think it came at the worst possible time. And we had there was a very strong reaction to it within the organisation, because we were on the eve of closing the organisation due to COVID. We were moving all services by telephone contact. So therefore, we were rendering many victims and survivors into effective isolation, and we were bringing something in where the news headline that morning was that 90% of cases would be desktop through a speedy review, and speedy is the whole way through this 2-page document. It's mentioned quite a number of times, and that only 10% would go to full investigations. And there was no warning of that coming.
Do you think the word speedy was there to sort of show, well, we want a quick resolution to maybe move forward, or do you think that word was a bad word to use?
Well, I think it was an appalling word to use, because what you're saying is this will be dealt with rapid by desktop review. 90% will be put off to one side, 10% may go forward, and the even better news for you is we're going to close your case entirely. The message of that was appalling. And also as well, you know, the first paragraph of that was entirely around veterans and the Veterans Bill and the need to protect veterans. So here was, we were waiting for Stormont House. We felt there was an agreement among the governments, the British and Irish government and the Assembly. We were waiting for an action for that. We had no warning, and all of a sudden, in the middle of COVID, a 2-page statement came out that really was a demarcation away with absolutely no warning at a time when victims and survivors were most vulnerable. First paragraph of it was around the need to protect veterans, and then it moved on to victims and survivors. And you know, even as of last week, we had one call with the Secretary of State. We've had nothing since. We have asked for meetings with the NIO officials. We've had 2, which we have asked for. And we were told there was going to be extensive consultation. We haven't seen that. We were told that there would be papers. They haven't come, and I understand maybe they won't come. So it's really a very, very difficult position for victims and survivors to be in. And I really can't emphasize enough to you, it really feeds mistrust. It feeds a sense that we don't matter, and that this simply is about veterans and is not about addressing the needs of victims and survivors. And that is grossly unfair. It's very unfair to victims and survivors to do that. And I was very robust with the Secretary of State when we spoke to him, because I said, we're rendering people isolated within their 4 walls. And what will they have? They will have the television, they will have the radio, and we will have political programs that will unpick this and go over it and make an absolute, will make the case for it. And that's when people are most vulnerable. And I think we've been very disappointed in relation to the fact that we cannot see what the details of the proposals are, and how it's going to be taken forward.
Do you think maybe the reference to veterans might also have a bearing on cases in Afghanistan and Iraq, where, as an English MP, my post box is full of people concerned that people who have maybe, various lawyers, companies, going on fishing expeditions, and maybe that context wasn't maybe understood, the read across between veterans in Northern Ireland and veterans who've subsequently been involved in actions around the world?
I think I can understand in relation to the constituency you serve, and I can understand why that would be the case. However, we were waiting on the Stormont House process, which was to bring an impartial, independent process to all victims and survivors. And if you look at the first paragraph of the opening statement from the Secretary of State, it was entirely about, ensuring equal treatment of Northern Ireland veterans and those who served overseas. I mean, that was the first paragraph of it, and then it went on into victims and survivors. And I think that is regrettable, because I think all victims and survivors deserve fair and equal treatment. And it seemed that this push was coming because of the legislation for veterans in relation to the overseas, and that it wasn't coming in relation to victims and survivors per se and Stormont House, and that was regrettable. Okay. And I mean, we even as of last week, officials have been briefing the Sunday Times and Sunday Express, which again was focused on not around Stormont House, but was around in terms of the protection of veterans in relation to the legislation, and that's not helpful.
Okay, maybe if I could bring David in and ask him how the consultation in the run-up to the two-page statement, which has been described as a bolt out of the blue, compared to consultation and discussions ahead of the Stormont House Agreement, which I think was more of a process. Do you think?
Yes, sir. There's no doubt that previous consultation has been much more extensive. I don't know whether one of the there are two cynical views about the lack of consultation and the lack of detail in the written statement. One cynical view is that it's only about the MOD and protecting veterans, and as you rightly say, more focused on Iraq and other conflicts rather than Northern Ireland. And Northern Ireland just happens to be a consequence of that, and has to be kind of there'll be an obvious linkage. The other cynical view is that this is just to kick the can down the road, knowing perfectly well that this will be judicially reviewed. There'll be all kinds of concerns that will just take years to resolve. Personally, I'm not averse to having a process that is speedy, although I agree with Sandra, that's perhaps not the best word to use, but something that deals with the issue urgently and effectively. I'm not against that. But this ministerial statement does just seem to have come out of the blue. I mean, I wasn't, and as far as I know, nobody else was aware of it until it appeared on the 18th of March, and that's unfortunate.
Thanks, Dave. Back to you, Mr. Chairman.
Thank you, could I just ask very quickly, and I think probably Sandra, on this pace question, this speed question. And you talked about you're seeing younger brothers and sisters, children, grandchildren coming to you to seek your services and support. Is it in that balanced judgment question? Is it more important to try and deal with these matters whilst the largest cohort of survivors are still alive, or to have an elongated timetable, which just as by a nature of demographics, people are dying?
No, I mean, I believe it should be in people's lifetime. I believe that, I mean, we deal with people day and daily who don't get the answers that they want, and it should be within their lifetime. And when I say in relation, it depends what you mean by speedy, Chair. I mean, if you're talking about a full investigation, I mean, Operation Canova has been in place a relatively short time, and they, as far as we understand it, have submitted files and are coming to a stage in their process. That has been a fairly rapid, maybe, process in overall legacy terms, which seems to be delivering. So I think it is around how that it has adequate resources, it is adequate personnel, that it is a fully compliant process. And I think it's the sense that if you looked at this, it was, I mean, there was no role even for victims and survivors. It was going to be a desktop review, and either you went one way or the other. You either went forward to prosecution or you didn't, or to the chance of further investigation. It is very important.
So in summary, your concern is to make sure that it is done in a timely way, but adequately resourced, so that it is done properly, rather than speed leading to a rather flimsy approach. Is that a sort of fair assessment of your position?
Yes, it needs to be. Sorry, you broke the internet connection broke for me slightly, so I wasn't able to catch your last part.
Oh, sorry. In essence, your concern is that you'd like to see this done quickly, i.e. in order to make sure that the largest number of victims who are still alive can see justice done, in inverted commas. So therefore, as far as you're concerned, it's not so much the speed which is the question, but to make sure that it is dealt with, that it is adequately resourced in able to deliver that comprehensive approach at an appropriate speed.
Absolutely, and that it's fully compliant, independent and credible, Chair. It must be fully compliant, credible and independent, and build trust and confidence with families.
And very quickly, investigative procedures and standards, contemporary or as applied at the time of the event?
In relation to the standards set, well, there would be into
both the standard set and also for how, if any investigations are to take place, i.e. something that happened in, let's say, 1975, should they have the investigative norms of 1975 in place, or should we be imposing 2020 standards, which are, of course, entirely different and very much more sophisticated?
Well, I think that every opportunity should be taken, so it should be current, and it should be every opportunity should be taken to review the information, recognising the context that existed at that time. But I mean, there will always be new forensic processes in place. We have seen the benefit of that, and if a full investigation comes, then it allows, and I mean, investigation is only as good as the information available to it. So there must be full access to information to give it the fullest picture. You know, at the end of the day, Chair, we now are in a situation where this is the last throw of the dice for victims and survivors. We recognise that. This is the last opportunity to get this right, and it has to be right. And therefore, it should be as full as possible, applying today's standards, and make sure every evidential opportunity is followed up on.
Thank you very much. Stephen Farry.
Thank you, Chair, and good morning to Sandra, David and Kathy. And just to put on record our acknowledgement of the work you've done around the victims' pension in particular, and also to recognise the huge pain of the intergroup and the wider victims of the current impasse. Most of our questions are running into one another, and you have probably addressed some of my questions already, in particular to your answers to Bob. But just to frame that perhaps in a different way, you've identified the veterans issue as being the prime motivation around the change. If that MOD legislation was to be extended to Northern Ireland, what would be your view of the impact of that on the ability to sustain any comprehensive, inclusive process in Northern Ireland around legacy?
Do you want me to answer that, Stephen?
Sure. Yeah.
I think it'd be very difficult. I think that, in fact, I think for many people it'd be quite intolerable that that a process had been brought in, and that we had failed to implement a full legacy process. that looked at every case and looked at them in a fair and open way. So there's no doubt that in relation to them, there must be a full review in all cases. And I think that the community, I mean, we're saddling the community with the past, and many families want this released. They want to be able to move forward. They don't want to hand this to their children or to their grandchildren. And yet that's what we're doing. So there needs to be a clear process in place. I think it would be very damaging for the legislation to apply to Northern Ireland in the absence of any other processes to deal with it. It would be quite intolerable. Can I maybe refer that to my colleague Kathy or David?
I was just going to say, Kathy, forgive me. I'm told you've been waving at me, but I haven't seen the wave, so forgive me. So just shout at me. You're obviously on my Nelson side of my site at the moment, so I'm going to go to Kathy Curran first. Kathy.
Thank you, Chair. No, I just had a couple of points to make really in relation to the previous question. I think you can't underestimate the power of establishing trust and confidence with families. What we have seen through the Operation Canova process has been families and individuals who have come forward and provided information that the investigation never had before. Families who have never been asked to give statements with very valuable information, doing that now, and actually bringing forward items which can be retested under new forensic tests. So, you know, having that, establishing those relationships with trust and confidence has been very powerful and has opened the door for a lot of new information to come through. So that's been really beneficial for everybody and the investigation. In terms of the veterans issue, and if we were to legislate for that, I think that would be in contravention of Article 2 of the ECHR. That is an ongoing obligation. It will continue regardless of whether the government decides that cases should be closed, which I don't think is a legal position that they can take. You know, it's something that we need to adhere to. That's enshrined in the Good Friday Agreement. It's part of Stormont House. It's part of our Human Rights Act, and we can't ignore it. And it will be subject to repeated legal challenge. And it will essentially just bog this whole proposed new system down in legal challenges. I mean, I've heard the term lawfare used before, and I think really, you know, if we had a system that delivered for people, they wouldn't be in a position where they had to rely on going down the route of civil actions constantly to try and get access to information or disclosure. So essentially, let's have a system that works for people so that we don't have to rely on going down that route.
Okay, thank you. Sandra, had you finished?
No, just I wanted to say that, you know, veterans deserve justice, truth and justice, but so does everybody else. And, you know, under the current processes that are being proposed, there is a direct, you know, impact even for veterans' families here who lost their loved ones here, for police families, you know. So, you know, there's no doubt that veterans deserve truth, justice and respect, but at the end of the day, so does everybody else. You know, it should be a process that applies to all.
Thank you. Mr. Farry, do you want to come back?
Yes, thank you, Chair. And again, to our witnesses, you've already touched on this to a certain extent, but just ask the question more formally. Are there certain aspects of the Stormont House Agreement that you would have liked to have seen the government change or revisit? And in reverse, at the same time, what do you regard as being the core aspects of Stormont House that are absolutely things that we do need to preserve in whatever system we have going forward? Thank you.
Sandra?
I was going to, can I ask Kathy maybe? I'm just conscious I don't want to.
Yes.
Kathy, would you like to take that?
You want to share the limelight?
I think the core tenet needs to be that there needs to be a workable, operational, effective investigation unit. Without that, it's hollow, frankly. You know, I'm reflecting on some of the principles as well that Stormont House was underpinned by. Things like promoting reconciliation, upholding the rule of law, acknowledging and addressing the suffering of victims and survivors, facilitating the pursuit of justice and information recovery, human rights compliance, balanced, proportionate, transparent, fair and equitable. They are all excellent principles to underpin this process, and unfortunately I really don't see how that is reflected in the new proposal. It's hard to do that anyway without any detail. But, you know, looking at things like promoting reconciliation, you know, if you're putting speed over quality in terms of investigations, that's not going to promote reconciliation. It's not going to give people dignity and respect. It's not going to lead to acknowledgement. There are questions around the legality of things like trying to close down cases. So where we're upholding the rule of law, I'm not sure. You know, facilitating the pursuit of justice. Well, you're not facilitating the pursuit of justice if you close a case down and tell somebody that they cannot proceed. And also, I don't see that it's the investigations unit's remit to say that a prosecution can't take place. That remit is within the Public Prosecution Service to decide whether a case meets the evidential test and can move forward for prosecution. So, you know, there are those key principles that underpin Stormont House Agreement, which was, you know, the outworkings of an intensive talks process and which had broad political consensus. That's now been disregarded, not to mention the kind of co-sponsors in terms of the British and Irish governments who seem to be disconnected on this new proposal. So, you know, really, we think that Stormont House, while it wasn't perfect, as Sandra said, was the last roll of the dice, and we tried to be very constructive in our feedback and in our consultation with our members. And unfortunately, it sort of feels like the goalposts have been moved a little bit. So, you know, while it's okay, sorry.
No, please, just finish up on that one, please.
So I suppose really it's about keeping true to the principles of Stormont House. The ministerial written statement said that it adhered to those principles, but we really don't see how it's reflected in the proposals.
Colleagues and witnesses, we've got time runs on. We're halfway through what we wanted to cover. I want really sort of brief, focused comments, questions, remarks, and I look for an example to Claire Hannah for that, and then I should come to Caroline Ansell. So both of you stand by. Claire.
I'll be honest, your answers have been so comprehensive that the questions can be shortened. I was going to ask you if there was anything you thought the UK government needed to do to make these 18th of March proposals compliant with Article 2 investigations. I think, Cathy, you probably articulated that they will have to completely revise them. But do you think the March proposals can be rehabilitated in a way that makes them compliant?
Do you want me to answer that?
Yes, Cathy. Go on.
Well, I mean, it's hard to know without the detail. So, you know, in order to look at something as complex as an investigation which needs to be compliant with Article 2 of ECHR, we can't judge that on a 2-page written statement, which is vague and is just not substantial in detail at all. I think, you know, the things that make an investigation Article 2 compliant are independence, effectiveness, access to information, a degree of public scrutiny involving the families, you know, and giving them their place, definitely. And it does need to be prompt, but as I said before, it can't be prompt to the detriment of the quality of the investigation. It needs to be independent. There are lots of questions around amalgamating, you know, information retrieval with an investigative process. There were already issues around having two independent from each other institutions conducting different remits, but, you know, at the same time. There were concerns about information. There were concerns around, you know, how robust the protections would be for people who wanted to give information through the retrieval process. So now putting that under one roof, it presents a whole new set of problems. So in terms of it being, you know, compliant with Article 2, we need to see the detail, but, you know, through that written ministerial statement, it doesn't certainly present itself as compliant.
And then specifically your assessment of Operation Canova in those terms, then in terms of how it places emphasis on the victims, do you think that has worked?
It has been an excellent process from start to finish for many of the victims. We only work with a portion of those people who are engaged with the process, but the people that we do support have been impressed by it. Let's say we started off the process 4 years ago, and we did a sort of benchmarking exercise where we kind of took a reading from our members as to where they were in terms of their trust and confidence. And it wasn't good. You know, they hadn't had good experiences with the police previously. Like I said, they'd been through different processes, and it had been a very piecemeal approach, as is the legacy landscape today. So going through a process where they were allocated a specific team, where they had regular contact, they had access to the various degrees of management throughout Operation Canova, including the operational command, has gone great strides to kind of instill confidence and trust in them. And let's not forget, we're talking about families who come from a background where traditionally there has been a mistrust of the police. So it's one thing to kind of undo the past failures, but it's quite something else to kind of step in and give confidence to people who come from a community where there was a reluctance to deal with the police whatsoever. So, you know, I think that speaks volumes around how Operation Canova has handled itself. But really what is very important is that the right people are involved too. It's become very apparent that John Boucher has been able to provide the right type of leadership for this process. And he has also brought on board with him, you know, in his 72 staff, people who share in the values and want to see, you know, the best outcomes for families, and that has been incredibly important as well. So it's about the right policies, the right infrastructure, and the right people.
Thank you. Caroline Ansell.
Thank you, Chair. I think I have a sense of how you might answer this question, but I will put it nonetheless. And it's essentially around balance, and whether you think the proposals, such as they are, and thinking back to earlier comments, do they strike the right balance on setting the threshold for cases going forward for full investigation? And Sandra, you said earlier in this session that there should be no bar to service provision. Where might you see the bar? And I'm thinking also of David's comments around expectation of prosecution, and whether sort of false hope is itself quite wounding then, and whether there is any merit in that idea of an open case being an open wound, and whether closure doesn't give some sense of peace. So around the balance and the threshold.
I think it's very difficult to make comments on the threshold just on the basis of the two-page document. I think the difficulty is if you close cases. So let's go. I'll go back one step. For families, how many families are waiting and looking for prosecution or have an expectation of it? And if you read the evidence which we've read that's been submitted into you from John Boucher, from the Operation Canova team, they were very clear in relation to, I suppose, the opportunities to give families information. I think that many families want that. They are looking for clear information, a clear investigation, and to know, and the only way to get that information is an investigation. You know, and I'm happy to talk about why I think there are limitations in relation to information retrieval from paramilitary groups or whatever. So they need to have a full investigation. They need to be given every opportunity and to have full information from the organisations which hold it. If you then those cases move forward, and you say that's closed, what are you saying to families? You're saying to families, you're basically, the government, by these processes, you're saying this is a defective amnesty. If you're closing cases off, that whatever comes in the future, you can never go back to relook at their case. Now, I'm sure MPs that across your constituencies, and whether it's Scarborough or Dorset or Eastbourne or wherever, you have many unsolved murders across those areas. Can you imagine going and saying to your constituents, your case is 20, 30, 40 years old, there's no viable chance of prosecution, or if you're getting everywhere, we're just going to blanketly close this off? You wouldn't do it. And I suppose my sense today to you and plea to you today is, why would we do this to victims and survivors of the Troubles? Why would we say to them that a case in Scarborough matters, but a case in Northern Ireland doesn't because it's Troubles related? So I understand there are many families. I think that there are families. I remember a lady saying to me once that the thought that whoever had killed her son, that the knock at the door could come at any time, settled her enough to know that forever, as long as they lived, they would know that they might still be held to account for that. Could we take that away from her? I don't think we could. Does she deserve a full investigation? Absolutely. And I think for many people, it's the sense of knowing there's been a full investigation into their loved one's death. But I think to move to close and to say, based on what we've seen, that you're going to close this and it's closed forever, whilst that's very appealing at a government level, it's very appealing at a variety of levels. For the families, it's really a very detrimental statement, and in fact, what we would argue is a de facto amnesty, and that is wrong.
Okay, David.
Caroline, would you like to come back?
Well, I would only just say, you talked about English constituencies, but of course my constituency was represented by Ian Gow back in the 90s, who was himself murdered by the RAA. So it does reach far and wide, and my community remembers still to this day. So I really do understand what you're saying around that. So just though to your point on threshold, then your position is that every case should carry a full investigation.
Absolutely. People deserve that. They need to know their loved ones better, and they deserve that. And with the right team and the right process and the right policies and the right guidance in place, that can be done. I think Operation Nova have demonstrated that.
I was going to say that substantiates that sort of hope that the future might bring new evidence to light as well.
Yeah.
Thank you. Gregory Campbell, please, and then I'll come to Mary Foy. Gregory.
Thank you, Chairman, and just to concur with the good work of all the other members, to each of the three witnesses we have on all the work we've been doing. But just one very brief issue, Chairman, I had, and it was this issue of the veterans kept coming up. I don't think people would want misunderstanding to occur that many of the veterans themselves are victims and survivors. So they're not sort of separate categories of people to be dealt with separately. Many of them would fall into that same category of being both a victim and maybe a survivor. But just to look at this in the round, there is obviously widespread dissatisfaction with the proposals. Do you think in the very short term, because I mean, if we spent another 6 months or a year, we may be able to adjust this to get it in a better place where more people would be well disposed towards it. But do you think in the short time that we have that it is doable to get it to a place where the majority of victims would at least be content that there is a better prospect of getting some form of satisfaction if ever they can?
I think there's an opportunity, and I do believe that this is the last opportunity to do it. That we need to, that the proposals need to provide reassurance, to provide a very clear process meeting all the various Article 2 compliance requirements. That if that is in place, and that it is as described. I mean, at the end of the day, Stormont House did follow a very extensive consultation. The response to it was absolutely huge. I mean, 18,000 I think is good for a consultation response. And I suppose we have seen each time that external reports are done, the same issues keep coming back, the need for a historic investigation unit that looks fully at cases. And I think that has to be done, and that we need to provide trust and confidence that will be in place and that it will have the credibility to deliver. At the minute, in terms of how this, because of the lack of information, the lack of consultation, the lack of engagement, the lack of moving away from Stormont House, all of that feeds mistrust. And I think there must be a very firm proposal in place that we can see in relation to how this will be taken forward and how the structures and process will be taken in place. Okay. My colleagues may, Gregory, want to comment on that as well, Kathy or David.
Well, I'm actually keen, if we may, to move to Mary Kelly Foy's question. David, I'd like you to come in, please, first to answer with Mary Kelly Foy. I'm conscious of the time, and I do want to cover all the territory. Mary, you're muted.
Thank you, Chair. Yeah, you have addressed all of the issues that I was going to ask. I guess just very quickly though, what are the changes you think that need to happen to put victims first? What do you think would be a good outcome here? That's my first question, and then after you've answered that, I do have a small question after
Yes,
that.
of course. Right, let's turn to David Clements. David, let's have your thoughts on that, please.
Thank you, Chair. I think that's a very pertinent question because from my point of view, putting victims first is the most fundamental issue. Going back to Caroline's question and Gregory's comment as well about balance and thresholds and so on, the issue of investigations is complicated and difficult, and the prospect of an outcome that will satisfy victims is remote in terms of a prosecution and a conviction. So what other ways can any process support and encourage victims, empower them, give them their voice, and give them a sense that their loved one mattered, that they're not just a statistic? Now, some kind of investigative process, I think, is probably essential for that. In the past, I've argued against the Historical Investigation Unit in terms of its cost, its remit, its prospect of coming to satisfactory outcomes for victims. I think probably my position now is that we do need some kind of investigative process, and I have been encouraged, like the others have said already, that John Boucher is a man of character who has been able to drive the Canova process in a very positive way. So there is a model there that now I see may be, in terms of investigative process, helpful. But I want to bring in the other issues, Mary's question: what will help victims? Having their stories told, having a sense that they matter, having a sense that they have a part in the community. And that they're not a stumbling block. I think one of the things, going back a long time, there was I'm not going to specifics, but there was a group who were supposed to be helping victims, and one of their staff rather colorfully, described the situation, summed it up, but the bloody victims. They're just a nuisance, and what are we going to do with them? And we don't want that to be the attitude that people have. We want support, encouragement, and a sense of being listened to, and sometimes just a sympathetic listening, be that from an investigative process or from a truth finding process, or just from a process within society that gives recognition to victims and their sufferings.
Okay, thank you. And I guess
Mary, very, very quickly, and then because we have about a minute and a half.
Yeah, well, I guess following on from that, why do you think, after such compelling evidence given over the years, that the government seem to no longer be listening to your voices, the voices that you desperately need hearing?
I think in a nutshell, it's because legacy is contested. And there are different views and outcomes, and it's always going to be the case. And finding the answer is going to be difficult.
Can I add just one thing? And just as Chair, as a point of clarification, you asked earlier about the definition of a victim and our view, and I just want to put in the record that the victim payment scheme is not a service, so therefore it had to have a separate definition. It is recognition, it's acknowledgement. And it was important that it was structured in that way. And it's important just to put that on record.
Okay, thank you. Right, can I thank, on behalf of the committee, Kathy, Sandra and David for their time, for the work that you do, and for the way that you have answered our questions. I hope it hasn't been too horrible an experience for the three of you. Thank you very much indeed. I'm sure the IT people have advised you what you now need to do. We have our other three victims, witnesses, waiting for us. And so we will now move into the second session. But Kathy, Sandra, David, thank you very much indeed for your time. We're obliged to you.
Thank you. Thank you, Chair. Thank you, panel.
Thank you. Right. Thank you very much indeed. Yes, thank you, Bob.
Sorry, I kept my own count.
No,
so
thank you, Bob. Thank you. Yes.
Thank
you, Bob. Thank you. Right. Good morning, second set of witnesses. Could I just ask you, please, for the record, to unmute yourselves, to introduce yourselves, and if you'd just like to give a few introductory remarks as a scene setter before we turn to questions, that would be very helpful. Thank you.
Good morning, committee. My name is Kenny Donaldson. I'm Director of Services with South East Fermanagh Foundation and also spokesman for the Innocent Victims United umbrella organisation.
Thank you very much. Mr. Funston.
Good morning, panel. Thank you very much for a chance to speak to you here today. My name is Ken Funston. I'm the Advocacy Manager at SEF, and in that role I also provide advocacy support for the other organisations within the IVU.
Thank you very much indeed. Ms. Gallagher.
Good morning, my name is Iona Gallagher and I am the Advocacy Support Worker for SEF, and I support victims across Great Britain and I work from London.
Thank you very much. Do you want to give an introductory comment or two, or do you want to go straight into questioning?
Surely, Chair, we will maybe make some initial comments.
Please, yes.
Just to say, we firstly want to thank yourself and committee members for facilitating us this morning. We appreciate that very much. I suppose as way of context, just so everyone is clear, our own organisation, the ethos that we operate with is that we support all innocent victims of the Troubles, irrespective of their ethnic or religious background. And our services are delivered across Northern Ireland, the Republic, and indeed Great Britain. We're the one Northern Ireland-based group who have an office in GB, located in London. That ethos is extremely important to us, and I know that earlier comments have been made around the definition of victim, and I suppose, Chair, to save you asking that question to us, and we would make it very clear that the current 2006 order we don't accept and have challenged it for the last 14 years. There is an argument made at times that this is about services for individuals, and our position has always been that terrorists, perpetrators and or their families, of course, will require support in the context of what has happened, but should they be provided that support under the parameters of victimhood, we would suggest no, and we continue to hold that position very strongly.
Thank you. So do we take from that, thank you, Mr. Johnson, do we take from that that you are keen to see rapid progress made with regards to the victims' pensions and payments starting to be made as quickly as is feasible?
Absolutely, Chair, and I suppose what we would say in that regard is that Parliament has paved the way forward. Legislation is in place, and the Northern Ireland Executive is in breach of its responsibilities in actually delivering that pension, a pension that would make a huge difference to so many lives from right across our community. So yes, we would very much call for progress on that matter, and for those who hold up that progress, sanctions must follow.
And I think we heard from our previous witnesses that they had communicated their thoughts to the executive, but were still awaiting a reply, some weeks having sent that letter. From memory, I think early April was indicated. Have you made your views known as an organisation through to the executive in a formal way, and have you had a response?
Absolutely, we make our views known on this issue on an ongoing basis with all the stakeholders involved, and I suppose we've been extremely frustrated, and it has to be said that it was only 9 to 10 days out from the scheme actually supposedly going live that we were advised that it wasn't going to be going live at a formal meeting. That came as a great, I suppose, concern and shock, but just the level of how far behind the process we are with it is concerning. Victims are, of course, first generation victims are getting older, and many of them will not see the benefit of this pension if it is not instated ASAP.
And could I ask you just to give us a very, very brief flavour of the responses that you have had from those people with whom you work to this victims' pensions impasse? What are you hearing on the telephone and Zoom, etc.?
Well, I suppose we have an advocacy team, Chair, of 9 strong, and we've health and wellbeing caseworkers, so we have a lot of outreach people across Northern Ireland, the Republic and GB, and they are just receiving a sense of despondency. I have to say there exists currently a real deficit of trust on the part of innocent victims towards essentially the establishment. That has to be said. And what people, I suppose, have saw happen since 1998 is a subversion of the criminal justice system. And really, what we need now is for us to recalibrate where we're going, not continue to do things in the same way that we have done before. There are reasons why we are where we are, and people need to be honest and open about that. And let's build genuine reconciliation, not a phony kind, which is built on sand.
Thank you, Mr. Johnson. Let me turn to Mr. Pacey now, please, Ian.
Thank you, Mr. Chairman, and can I thank you, Kenny, and Ken and Iona for the hard work that you do and for the unstinting efforts that you make in terms of advocating and representing a traumatized group of people. And I commend the work that you are engaged in, and I know how difficult it is for you and how frustrating it can be for you at times, but thank you nonetheless, and very, very publicly. Kenny, could I ask you, if it's almost like the man who's asked for directions to court, I wouldn't start from here, but if you had a blank sheet of paper, how would you make these arrangements or make arrangements for victims and for legacy arrangements actually work that would satisfy the vast majority of innocent victims?
Thank you for your question, Ian, and for those kind comments. I suppose what we have said is we've obviously put forward our own paper, and indeed before the Northern Ireland Affairs Committee inquiry, we had submitted a paper to the Northern Ireland office. It has always been our contention that the HIU is a cumbersome structure which as well is very much weighted in the advantages of people whom were terrorists and or perpetrators. And we saw very little opportunities for the needs of innocent victims to be progressed through that means. What we have suggested in our alternative proposal is that the HIU would be housed within the PSNI. We acknowledge that there is a constituency of people whom contend that the PSNI is not acceptable from an independence point of view to investigate our past. And we have heard this morning already about the work of Boucher in terms of Canova and other forms of investigations that have been carried out by external constabularies. For those cases which allege wrongdoing of the state, they could be dealt with in that manner. But the vast majority of cases, which, let's be clear, 90% of the deaths in the context of the Northern Ireland Troubles committed by terrorists, murders, 90%. And those could be housed and looked at and examined through the existing parameters of the PSNI, with a beefed up LIB and with the right oversight procedures in place and independence, etc. So there is a means to do that.
And how would you address, Kenny, the issue of, which is sometimes raised, the quote, there's no likely successful prosecutional outcome, or there's no further material on file? How would you address with that, and how would you manage, in real terms, that disappointment?
Liam, I just want to involve as well other colleagues at this stage. I know that Ken, in terms of his advocacy role, if you want to contribute there, Ken.
I think it's a very difficult question, Mr. Paisley, but the reality is, as an advocate, and that's all our staff, we have to be realistic when we engage with a victim or a victim and survivor. And I can maybe bring my own family into context in that situation. When my brother was murdered on the border, the perpetrators and murderers escaped back across the border. So the evidence or the potential openings in the case are actually in Southern Ireland. So that hence the difficulties in a lot of cases, especially in the border region, which are on our files. We've got hundreds of cases in that border area. And so we have to be realistic with a family and say, look, there are openings here, but this comes back into context what was asked earlier on about review of cases. Up Canova has been running 4 years with 80 plus investigators, stroke detectives on one focused case. We're looking here at revisiting thousands of cases, and the time span will be decades at least. And do we look at each individual case as a serious case review or a full murder investigation? Which again, if we go into a full murder investigation, again, we're looking at years and years, and the families haven't got that time. In reality, they haven't got that time. And your point is, in my own family in particular, at the moment, we have no openings in the case of my brother's murder. But ultimately, it comes back to the question you're going to ask later on in relation to the new Northern Ireland Office suggestions paper is you still can't close those cases because potentially something may come forward in the future. And a case in mention I may bring up is the murder of a police officer called Michael Ferguson. Years later, a man walked into the police station and confessed his involvement in that murder. And that's, to me, a case in mention where we cannot close these cases, even when there's nothing available.
Yeah, no, I definitely get the issue of and the opposition to closing and as if the past is over. The past is never over. Historians will always want to go back into it, and I think that issue is well made. It's well made by you, Ken. And you've addressed this issue of things are left to fester. Really, you mentioned the issue of the Republic of Ireland, which we haven't really explored with other witnesses. There's no FOI available in the Republic of Ireland. There's no inquiry mechanism whatsoever. And yet, as you've outlined in the tragic murder of your brother, the Republic of Ireland authorities have some role in this. How would you open up that aspect of addressing legacy?
What I can say, first of all, is working with any case, whether it's with the UK or the Republic, is difficult and it's slow, it's cumbersome. It wears the advocate down, never mind the family, because the family obviously have come to us and looking at answers. But what I found in my experience working with authorities in the Republic of Ireland, it's nigh on impossible to get anything from them. One case in particular, I saw...
For the record, that's nigh on impossible to get anything from the Republic.
Nigh on impossible, that's correct. A case, I met the Minister for Foreign Affairs last year, Mr. Coveney, in his office in the Dáil, and there were a level of promises made which they've since said there will be nothing available in that case. They're not prepared to help us. Where there's allegations of state actors in the Republic of Ireland being involved in the murder, and that murder, allegations of them being involved in that murder. I have engaged on behalf of the family with the police ombudsman in Southern Ireland, and after 3 years, and in total so far, 34 unanswered emails from that organisation. After 2.5 years ago, they promised they would look at the case again. They've closed it down. They don't want to know. I brought that case up with Mr. Coveney in the South, and he said that ombudsman organisation are virtually untouchable, that they are a standalone organisation and the government can't interfere. And there are many, many other cases like that. I have another case where a gentleman was murdered right on the border, and his body, he was murdered in the south, his body was dumped just across the border in the north. There are many allegations against what went on in the investigation on the southern side, and unfortunately, again, we've hit a blank wall, although the Garda themselves have now agreed to have another look at it. Okay. So those are just a small example of the issues we face working with the South.
Mr. Chairman, it might be worthwhile if we go back to the people who we've been talking to in the Republic of Ireland and ask them if they could maybe respond to that allegation of unanswered emails, 34 unanswered emails about murders in the Republic of Ireland. I think that might be useful because we've had some joy with the Corporal Elliott case, as you know.
I've taken a note of that, Mr. Paisley. Mr. Campbell has indicated he wanted to come in. Gregory.
Yes, thank you, Chairman, and good to hear from Seth again. Just on the issue that Ian raised there with the Republic, given, I mean, obviously there's a huge distinction in terms of the scale, you know, because there are 3,000 deaths in Northern Ireland and significantly fewer in the Republic. But almost the difference in scale has to some extent allowed the authorities in the Republic not to answer what Ken's point about the scores of emails unresponded to. It almost seems as if it is, and I don't wish to minimize this, but it almost seems as if it's a forgotten issue or matter in the Republic. And I mean, while the committee have limited remit, obviously, I mean, I take it is a matter that you would want to see the Republic's authorities, particularly the new government, Michael Martin and company, who've been promising all sorts of changes, that this may be something that they should reopen to try and see if, as a legacy matter, make an attempt to try and bring closure to people along the border, particularly.
Okay, Mr. Donaldson, do you just want a very pithy response to that, and then
Yes.
we'll I'll
Thank
turn
you,
to
Chair.
Mr. Coulter. Thank you, Gregory.
Yes,
Mr. Donaldson.
Gregory, thank you. And yes, absolutely. I mean, in terms of the southern state, in many ways, it has adopted a position over the years where it's almost suggested that it was an independent onlooker to events that were unfolding within Northern Ireland. And the truth and reality is that there are 88 innocents murdered within the jurisdiction of the Republic of Ireland. But we, with our research, would have strong suspicions that there are between 530 and 550 murders along our border corridor, which directly connect to that jurisdiction. And I suppose what we would also say in respect of the wider issue of the UK government's position on legacy, often almost on a monthly basis, we hear from Dublin in respect of cases connected to Northern Ireland, whether it be the Loughlin Island case, whether it be Ballymurphy, whether it be Bloody Sunday, etc. Do we as an organisation have a difficulty with the Southern government advocating in those cases? Absolutely not. But what we have a big issue with is their non-advocacy for our cases, which connect to that border corridor. And we'd also suggest that the UK government, in respect of legacy, often does legacy like we play the game of cricket. And there isn't enough probing questions and analysis of the Republic of Ireland state's role and responsibility over the years of the Troubles.
Mr. Chairman, could I briefly just ask that SEF supply us with maybe a very quick analysis at the end of this meeting in writing of those 530 to 550 border corridor cases?
I think that would be incredibly helpful. Could I just ask Mr. Donaldson very briefly, the issues that Mr. Funston has raised in answer to colleagues' questions would appear to indicate a more of a collaborative all-Ireland approach to this issue. And is it your assessment that the ministerial written statement aids that desirability, or does it impinge upon it?
Well, it's a difficult question again, Chair, because we're not privy to what conversations went on or didn't go on between the UK government, the NIO, and also with the Southern government. We've heard some speculation.
Well, I think I can help you on that. I think our understanding is that there was little, if any, discussion between the Northern Ireland office and the government of the Republic prior to the publication of the written ministerial statement.
Thank you, Chair. I think what we're saying is we have a change of government in the Republic of Ireland, and with that comes opportunities. And what we feel it would be very important at the early beginnings of that new government is that there would be a statement of intent come from that government in respect of this issue, and that we would hear from Micheál Martin and from colleagues that there is a desire and a willingness on the part of the Southern state to come to this issue with a generosity of spirit. The reality is, of course, the Republic of Ireland state, if it were not to engage with whatever structures are in place or engage in a level comparable to the UK state, then those whom we represent are going to continue to be treated in an unfair and unjust manner. So this requires the absolute involvement of the Southern state. We look to, obviously 50 years ago was the beginnings, the arms crisis in the Republic. There continue to be issues from that period of time which have not been fully probed and answered. And I remember the question asked of me by a journalist in Northern Ireland, but Kenny, there's been an inquiry. You must accept the outcome of that inquiry of that time and move on. And I said, oh, right, you mean just as people have done so in Bloody Sunday, in Loughlin Island, in every other of those cases. If there is not a confidence on the part of those who have been harmed that justice and accountability has been served, then of course we reserve the right to continue to probe those issues.
So would you prefer to see a greater attention to the two governments being in much closer lockstep in response to this issue, particularly in relation to your community being a border community and far more sensitive to the approaches of the two governments?
Well, Chair, I suppose what I would say first of all is what we need to recognise is that An Garda Síochána does not even have a legacy unit within its own force. The other matter needs understood is that the Garda investigate the Garda. There is no independent oversight of the organisation. But we do want to place on record, and this is important, our view and analysis of the Troubles is that the great majority of An Garda Síochána members, as well as the Irish Defence Forces, did their role and duty with honour and integrity, as did those whom served within the Army and the police within Northern Ireland Prison Service in the greater majority of situations.
Thank you. Do you think that the written ministerial statement is, as it currently stands, is likely to deliver that sort of collaborative approach between north and south of the border?
I suppose, Chair, it's not there presently because there's such limited detail. But what we would say is, if you look at the example of the pension for the seriously injured, you might think this ironic, but we are the organisation who would be understood to have roots within South Fermanagh, where the overwhelming majority of our members would be victims of paraterror at that stage. And obviously we have evolved into a much broader and wider organisation over the years, serving all innocents, irrespective of ethnic or religious background. But let's be straight here. Any Irish citizen whom was injured as a consequence of the Troubles and who lives in the Republic of Ireland, they are excluded from that pension as it currently stands. And we have called upon the Republic of Ireland state to step up to the mark and to introduce a comparable scheme so those individuals are also dealt with in a way that they should. We're still waiting to hear back, Chair, on that matter also.
I really am keen to get a yes or a no answer to a question which I think can deliver a yes or a no answer, which is there greater merit in a uniformity of approach to this issue from both governments, or that's yes, no? And if no, what is the merit of running a two-stream system?
Chair, I believe that there is absolute merit in collaborative approaches by both jurisdictions. I'm not suggesting a single All-Ireland unit, but I believe that the Republic of Ireland needs to step up to the plate and offer something comparable.
Okay. Mr. Goodwill.
Thank you. In the first session, I asked about the level of consultation ahead of the ministerial statement, and the impression we got was quite clear that there was no consultation. It was a bolt out of the blue. So maybe can I ask the question in a different way this time? Say, what reference do you think there was in the run-up to the statement in, for example, the 18,000 responses to the Stormont House Agreement, or indeed the regular engagement that goes on at a political level locally in Northern Ireland?
Okay, I suppose, thank you, Chair, and thank you for your question, Robert. I suppose the point here is that we have obviously dissected the summary of responses to those 18,000 consultation submissions at the beginning. And there obviously are very, very significant issues with Stormont House as reflected in that summary of responses. And the total almost non-acceptance of the issue of non-criminal police misconduct, and the level of proof and burden of proof that the limited amount of it exists there in order for findings, very severe findings, to be found against individuals whom formerly served in the police. So what we would say is there is an acceptance from those who are realists at this stage that Stormont House as configured is dead. It's dead. Mm-hmm. What we now require to do is openly and honestly examine why is it dead. And if people believe that they can reignite that Stormont House Agreement without the support of the largest consortia of victims organisations in the sector, 23 organisations part of Innocent Victims United, 11,500 membership across Northern Ireland, the Republic and Great Britain, then they're deluded. They are doing it for a different purpose if they push that agenda. So you need to engage with us more fully around what is realistic, what is fair and equitable, and what ultimately is going to be deliverable for victims. What outcomes are we seeking to reach? We want a lasting peace in Northern Ireland. We want genuine reconciliation. but we do not want to continue this phony approach that has been operational for 2.5 decades and which has brought us to a period of paralysis on these issues.
Okay, and regardless of the dissatisfaction with consultation, do you feel that the statement is the basis for progress, or should it be torn up and a fresh start made?
I think that two-page statement, we would want to see what was behind it. And it smelt like an amnesty by stealth, right, effectively, and we would guard against that particular approach. My colleague very well made the point earlier that there always exists the potential for someone to explain themselves to have committed a crime, or indeed for new evidence to come forward, and that must always be on the statute book. If the UK gets into the business as a state of writing off crimes off its statute book, and these were crimes, they were murders or killings, then what message are we sending out as a nation in that regard? We don't wipe off other crimes connected with other forms of activity, so why would we do it in the context of the Troubles? Justice must prevail.
Okay, I think that's very clear. Thank you, Chair. I know you're pressed for time, so I'll hand back if I may.
Mr. Farry.
Thank you, Chair. And again, good morning to our witnesses, and just again put on record our appreciation for the work that SEF and IVU do on behalf of victims. Again, the questions are running into one another, but I just want to pick up then, Kenny and others, on your last comments, and just almost beg the question: if you're concerned about the latest NIO statement, very clearly you're deeply opposed to Stormont House. Where do you see a consensus being formed alternatively to those mechanisms, given that there is such a diverse range of opinion within victims, and also bearing in mind that there is a need for any mechanism to be Article 2 compliant?
Thank you, Chair. And before bringing all our colleagues, I suppose the crux of this is that we had a process in Hass O'Sullivan where there was quite an open door policy to victims and survivors in terms of presenting their case and their position on these matters. We then moved to a Stormont House process where effectively we were locked out of that situation, and where engagements were completed amongst politicians and also civil servants. That was a failing, because what was then presented was presented as a fait accompli. And the truth is, with the greatest respects to people who are absolutely trying to do their best within the political realm, those 4 pillars, if you like, within the Stormont House agreement process, not many people out there in the community would have a difficulty with those four pillars. But folks, the devil's in the detail. And what was intimated at that particular time, and what then that is morphed into in terms of the bill and the associated outworkings, was a very, very different animal. And people need to be, I suppose, doing an analysis of why and how and what individuals were involved in that process within the NIO and external to the NIO who had pressure to exert at that particular time. Because what we have now is not something that we can buy into. And every representative within the Northern Ireland panel today on the team knows that. And so too, we have made that clear to the Conservatives and to Labour. So we need to get realistic now. We have put forward a paper which looks at the investigative issue. We would seek proper engagement around that particular matter. We have put it on record there this morning that for those cases which allege wrongdoing by the state, we acknowledge that there's going to be pushback on that matter, and people aren't going to be happy with an internal investigation of those matters by LIB. Then we look at the framework of voucher or another external to take on those particular cases. It's there, folks. There needs to be proper engagement around that structure.
Farry?
Chair, if I just could come back on a couple of points. If I could ask Kenny and indeed any of his colleagues to maybe factor in, first of all, the attitude of the police themselves to taking on ongoing legacy cases, and that they desire themselves for a different process to take this forward. And secondly, just to acknowledge what Kenny has said around the 4 pillars of Stormont House. I think that is a useful comment. But within that context, if there was the potential for significant change, particularly to the HIU process, around issues around the scope, terms of reference, and in particular the concerns that you've made around the non-criminal misconduct issue. Do you see any possibility of that being reassessed and reorientated to address your concerns?
Thank you, Stephen. Yes, Ken, you want to go in first?
I think Mr. Funston had indicated, and Ms. Gallagher, from a London perspective, or based in London perspective, we'd be interested to hear your views, so do feel free to chip in as and when you wish to. Mr. Funston.
Yeah, can I just bring Mr. Farry up a couple of points on that, please? First of all, in relation to veterans, we as an organisation have engaged with many veterans over the last number of years, and I cannot say that I have talked to one person who is definite in their response that there should be a statute of limitations. They don't want to be equated to the perpetrators, that they need something to stop them being investigated, because in their view, which stands out in statistics, very few of them are ever involved in misconduct or in serious crime. So there is not that will within the veterans community for a statute of limitations. Secondly, within Stormont House, obviously, and HIU, they talk about non-criminal police misconduct. And I mean, that is in itself, and that was written by human rights experts, that's in breach of Article 6 of a right to a fair trial in a public hearing. In a reasonable time, we have got veterans who are being investigated over and over and over on our books. We have one guy in particular, 10 years, 6 times he's been investigated, 6 times, 10 years. Where is the fairness in that? And this is where the problems have arisen, where we're seeing this now coming into government papers in relation to veterans because of these vexatious claims, vexatious attacks on individuals. So the structures of the structures of Stormont House, I mean, ICIR was never fit for purpose. It did not make any operational sense to run that type of organization alongside an investigative organization. And then you have an investigative organization, the HIU, which was going to have an investigative and an adjudicative role all in one. So judge, jury, and executioner within one body. So as it stands, I mean, the HIU, and you move on to the police, the chief constable says, yes, he does not want to deal with legacy. He doesn't want to deal with legacy probably for 2 reasons. He hasn't got the resources and the potential public impact. So if we deal with public impact, the PSNI as it stands have probably one of the highest percentage of satisfaction in UK police services at present. So what are they allowed to do and what are they not allowed to do? And there was a question in relation to the Jean Smith murder of assessing whether they had practical and operational independence. I mean, to me, that can be achieved by the Police Service of Northern Ireland, so that in fact the Police Service of Northern Ireland can be properly resourced with a semi-independent, semi-autonomous organisation within it, the legacy branch, that can take this on and take this on quickly in a fair and equitable way. We are looking at, I mentioned earlier on about Canova, 4 years on one focused investigation for over 80 investigators. Now, we have legacy branch who are presently working on a number of cases. If they were properly resourced, they could be up and running and doing this properly within a very short space of time. And obviously, in the present circumstances with COVID, finances come into the equation as well. And it obviously will be much, much cheaper. And I say they're ready to go. We get away from the other logistic problems of a new police service in Northern Ireland, the HI, with firearms training, with what operational limitations, within many other issues, within where they based, etc., whereas we have legacy up and running.
Chair, just before we would hand to Iona to contribute as well.
Sorry, Mr. I just wanted to come back to Mr. Farry to see if he had anything further to ask Mr. Funston.
No, I'm happy to move on. Thank you, Chair.
Thank you. Mr. Donaldson.
Sorry, Chair. Just for the record, I want to clarify, when we talk about the 4 pillars, I refer to justice, truth, and information, oral history, and also reconciliation. So those four concepts no one could have a difficulty with, but not the actual detail and content which is contained therein within the proposals.
Okay, got that. Yeah.
You didn't get me moving, Stephen.
Mr. Farry, do you want to come back on anything else, or can
I'm happy to move on, Chair, to the next question.
Thank you. Caroline Ansell.
Thank you, Chair. I wanted to ask about balance and whether you thought the current proposals struck the right balance in setting the threshold for those cases identified to go forward for full investigation.
Chair, if we could bring Iona in on that particular point, if Iona wants
yes.
to.
Iona, thank you.
And also Iona from the perspective of GB killings and how they are not incorporated within the current apparatus.
Okay,
Yes.
Ms. Gallagher.
Thank you. Yes, I think there is an issue with the acknowledgement over victims in GB, and working in London, I work directly with those victims, but for SEF, they have no other source of support. They have no services that they can engage with other than us. And considering bringing of cases, and as was mentioned earlier, the issues with limitation, we can look at the case of Young and Downey that was in the High Court in December 2019. I'm sure most of you will be aware of it, but for those of you that aren't, this concerned the Hyde Park bombing in 1982, and the case was brought by the claimant against Mr. John Downey for the unlawful killing of her father. And she won that case. However, that case illuminated a number of issues that GB victims face. Two primary issues. Firstly, one surrounding legal aid. And in that case, the claimant claimed legal aid on 5 separate occasions and was refused. That case highlights the issues that GB victims have not only in accessing services, but also in seeking legal redress and justice through the courts. And secondly, prior to the civil case, the criminal case collapsed in 2014. And that highlighted one of the issues that was referred to as a technicality, which was that Mr. Downey was in possession of an on the run letter. And while the outcome of the civil case in 2019 was successful.
Sorry, sorry, I'm going to interrupt you. I'm just receiving some advice that the Downey case is sub judice. So I don't want us to go onto that territory, please. Let me go back to Caroline Ansell to see if she wants to tease out any further information, but I'm not going down that road. Caroline.
Well, maybe taking aside the case, were there any more general points you wanted to make, Iona, before we perhaps go back to Kenny or to Ken?
Yes, I think generally just the issues that GB victims face would be two primary issues, would be seeking legal aid, being successful in their applications, and secondly, seeking support. And many of the victims that I work with directly in GB say that SEF are the only organisation that has contacted them, that has sought them out and works with them directly. So I believe they would be the two main issues that GB victims face.
Thank you very much for that. And Kenny?
Well, I was just before we leave, Ms. Gallagher, could you just give us an idea as to the figure of the number of people in GB who you're either working alongside or may have the potential to seek your services?
There would be around 150 victims and survivors in Great Britain, and I would engage directly and often with around 50 to 60 of them.
Okay, thank you very much indeed. Mr. Donaldson, were you coming in? Forgive me.
Yes, thank you, Chair. Yes, I suppose it's just to make that point that Iona has well made around the civil courts opportunities, that obviously there's such a high bar for victims in GB to reach in order to even have the opportunity in that situation. I mean, as a state, we obviously had a situation where an on-the-run letter, which subverted the criminal justice system in the first place, where that was able to be produced and that criminal case collapsed. And then we had a situation where those same families were forced to be beggars for not 1, not 2, not 3, not 4, 5 occasions before they were granted legal aid. And that is the situation with many other.
Okay, I think that point is made. Access to to legal aid in order to bring prosecution.
Sorry, Chair, but I was just going to go on to say that the criminal process then, in the context of what Stormont House laid out, that related specifically to killings which were committed in Northern Ireland. So murders that were committed in the Republic of Ireland and also in GB were not part of that process. So what redress is there for those individuals who were murdered in GB and or in the Republic of Ireland on these matters? Again, there was no joint up approach across the jurisdictions.
Thank you. I'm conscious of time, and I know that two colleagues, I think, are involved in events in the chamber for whom logistical support is required. I'm going to turn now to Claire Hannah, and then I shall come to Mary, and that will draw our proceedings to a close. Claire.
Thank you, Kenny and Ken and Iona, for your engagement and for the work you do throughout the year. And I think we're hearing clearly that you think the principles of Stormont House are solid, but you have concerns around the delivery, and you've raised rightly issues around disclosure, and I think around the trauma of the relentless and sustained border aspects, and I know that forms a big part of the work you do. Do you think that there are, based on what you have been able to see from the government proposals, are there ways that the 18th of March proposals can be made Article 2 compliant? And I'm aware, well, I'll come back. I agree with Mr. Farry that I think the PSNI have indicated that they don't believe that they can successfully manage legacy inquiries, and that they want to police the present. But do you have thoughts on a compromise around that?
Thank you, Claire, for the question. Yes, I suppose what first point, and I know Ken has touched on this, but we have always said it is not for the police service of Northern Ireland or for any of its chief constables, whether present or past, to indicate that they do not wish to take on legacy. It's not their call to make. If it's a matter of resourcing not being available to them to do so, then that is an issue that they need support with. But for them to make a political statement around their unwillingness to take on the past, we don't accept and don't agree with. The PSNI was a police organisation, an evolution from what had gone before. It has now secured the support of all political parties represented in the Northern Ireland Assembly and Executive. And are we really saying that we have photographs of people standing, encouraging people from across our community to join that police force, but yet they are saying that that police force is not fit for purpose to examine our past? We don't accept that. And following the Jean Smith case, there obviously were a number of changes which were made internally within the PSNI. We would ask for reappraisal of whether or not they are deemed now to have the operational independence to carry out work connected with the past. We've yet to see that advice unless any of you within that committee have done so.
Thank you, Claire.
What's your assessment?
Let me go back to Claire, and then Mr. Funston, I will come to you.
Assessment of Operation Canova?
Well, we have had some contact with it. Obviously, the particular, if you want to call it, concentration of cases aren't within our immediacy, if you like, where our core base is. But we have engaged with Operation Canova. There obviously is, I think, the process and how people were dealt with within it. There's positivity around. We await, of course, outcomes. So, you know, the process may be improved from what has gone before, but outcomes is what victims and survivors are seeking. And outcomes have been very thin on the ground. We have a situation since 1998 until now. Can anyone within the committee name to us those individuals who were on side with the Provisional Republican movement or on side with the Loyalist perspective on these issues, whom actually has been successfully prosecuted and then put to book in terms of imprisonment? No, what we've had is people who are offside with the police process who have been served up as almost token gestures. And we want a transformation around all of that. A matter which is of huge concern to us is that 3,000 weapons exist in a lockup in Northern Ireland concerning the past and the Troubles. And they're being used in a reactive way when the police, the current LIB, come to those particular cases. They are then checking out the ballistics, etc. There needs to be a focused piece of work done on that weaponry now, so that all those matches and linkages can be in place if we're genuinely concerned about actually serving justice for people. Or if we're simply going through the motions, then people need to be honest and say that.
If not Stormont House, Kenny, how do you think the issues of and you've referred to the sort of need for an holistic approach and a comprehensive rather than in your view case by case, but how do you think themes and patterns can be reflected if we move away from Stormont House?
Well, I mean, what we'll say first with Stormont House, or if you want to call it core grievance with it as well, is that it's in reverse. So in a sense, we have always argued that in the absence of the likelihood of large numbers of cases moving towards a situation where there is custodial sentences served, if you want to call the raw form and understood form of justice, acknowledgement is then what must be there for victims and survivors. And what we need at the absolute start of this process, which is what should have come between 1994 and 1998, is an acknowledgement of the wrong of violence across the board, carried out by Republicans, loyalists, and by those members of the forces who dishonoured the code and engaged in a criminal act. That's the foundation stone. You have that in place. The rest of this then is built on that firm foundation, and goodwill will result. But while you have a denial of that, and we are the core organisation in Northern Ireland who says that publicly, you're going to hear from victims' organisations, and they won't acknowledge the wrong of violence across the board. That's where the biggest problem is in all of this.
Well, I think we've heard from various organisations who very much do acknowledge wrong across the board. And Kenny, I agree with you in the concept of virtuous circles, that if that acknowledgement comes, good things will flow from it. But I believe some structures will be required for it, and I don't know that we have found much better than we will in Stormont House. Chair, that's okay for me.
Chair, just to elaborate.
Mr. Funston, I think you wanted to say a word or two.
Yeah, can I just come in there? Claire said that SEF in principle agree with Stormont House, and actually in principle we don't. There are serious issues within Stormont House. The whole structures do not make a logistical sense. HIU working alongside ICIR does not make any sense whatsoever. The Oral History Archives we think has merit, but must be a standalone organisation sitting outside any investigatory or adjudicatory board. And the last structure, looking at the themes, the IRG, possibly has merit somewhere down the line, but in principle we don't agree with what's in Stormont House. I think the government proposals recently in March, the 2-page, I understand some of the things they're trying to say, but I think the language was very, very clumsy when they talk about swift investigations. I mean, every investigation, every legacy investigation is subject to a review, and not in the review the way the HET did, which was totally unfit, but I mean a proper serious crime review. And any serious crime review cannot move forward to investigation unless there is new lines of investigation to be pursued. And that's any detective or any with understanding of the police service will know that. So ultimately, you can't just do a full-blown investigation in every case. That is impossible for 3,500 cases. Absolutely impossible. But yes, they do merit a serious crime review in each case.
Why is it impossible?
Because Canova has been going 4 years. We have not seen what has come out of Canova the other end as of yet. That was 80 plus detectives focused on one line of investigation. So if we look at 3,600 deaths and put a team on each investigation, unfortunately, and this is a sad thing to say, people, the older generation will have gone. My generation will be probably past it as well. It's going to take many, many decades, and that's the problem. We need to look at what's in there in the vaults and bring that.
So it's not impossible. It might be undeliverable as a result of lack of resources, but it's not impossible.
It's not impossible, no. We need to look at we need to have a team in place now to look at what's in the vaults and what is in there that will give us potential investigative opportunities. We are still seeing, myself in some of the cases, are finding nuggets that are available in there in Sea Park where the vaults are within the PSNI, but stuff isn't coming out because we're at stalemate. We need to get in there now and start looking and seeing what's available and getting on with it, not waiting through this.
So is it fair to summarise your view that you think that the process is being defined by resource and resourcing issues, both in terms of manpower and pounds, shillings and pence, rather than what is actually needed and then backfilling to deliver what is needed? In a nutshell, that's your position, Mr. Funston.
To a certain extent, but the reality is in Sea Park in County Antrim, where most of the evidence is held, the PSNI don't even know what's in there. Nothing is properly filed away. So we are finding things available in cases today that have been lying there for 20 years and nobody knew existed. So we need to get in there now. There's no use waiting and going over and over this for another 5 years, trying to get an HIU on board when we have a police service which could be properly resourced and get in there now and get on with it. I mean, the PSNI legacy branch also have around the same strength as Canova. They're only able to do a few cases per year. I mean, a very few. I mean, talking about ones and twos.
So it's quite a bold statement to make that the PSNI don't know what's in there.
I think it's a fair statement because the stuff is.
Well, Mr. Funston, it may very well be fair. What I was going to ask you is, could you substantiate it? You've referenced one case, but does that how does that take you to the fact that they don't know what is in there as a bold statement?
Let's put it this way: I know a number of cases where there are forensic evidence available, and it has not been unearthed. It's not been brought out because at the present time the resources are not available to do it.
So might I just how do you know that and the PSNI don't?
But the PSNI do know that, but they haven't got the resources to deal with it. That is the problem. And if we get, whether it's the HIU in another form or the LIB as it now stands, properly resourced, they can get in there and get on with this.
So I'm afraid you've now managed to confuse me. Is it that they know what is there, but they haven't got the resource to do anything with it, or they don't know what is there? You've managed, I think, if I've heard you correctly, and my apologies if I've misheard you, I think you've managed to say both within the last several moments.
Yeah, I would suggest there's a combination of both. There are cases that have potential investigative opportunities. They haven't got the resources to deal with them, and there's other stuff in there which hasn't even been unearthed at this stage.
And okay, and you're able to substantiate that latter statement?
Yes.
How? Because
I'm privy to a few things that went on within the police service in relation to one case in particular where the evidence was supposedly lost and was found per chance a number of years later and brought to the fore, which has resulted in the case moving forward. That's one in particular.
Right. That's interesting. Thank you. Mary Kelly Foy.
Chair, if I could just add there, please.
Mary Kelly Foy.
Yes.
Yeah, thanks, Chair. I guess we've heard that quite clearly that the proposals in their current form you're unable to buy into, if you like. And given that the statement described that this new system would be one of putting the victims first. Now, given that you're a voice of the victims, what is it? Can you clarify and confirm what changes you think are needed to put those victims first?
Mr. Donaldson?
Thank you for your question. Yes, I suppose where we're at with this is that there is language often trotted out, victim-centred approaches and inclusion and those nice buzzwords. And if I could first reflect on the point at the start of this session around the definition of victim, people need to be clear what the outworking of the 2006 order has been. We have a victims forum in Northern Ireland where perpetrators, people who actually had committed murder, sit on that particular forum at a time. That had the impact of excluding an entire constituency of victims and survivors who could not sit on that forum alongside people who were perpetrators. Imagine if we had a forum for victims of domestic violence or burglary, but that forum was also to be comprised with the people who actually committed the crimes. It would be an absolute nonsense. It wouldn't happen, but it happens in Northern Ireland. But whenever you say about what now would transform things, acknowledgement at the start of this process is the first absolute must. But then what we must have is, as we've alluded to with C Park, if the material is there, then get it properly coordinated, get it properly tracked, get that material and evidence on file, and then we can examine while there is proactive policing that can happen in terms of actually holding accountable these crimes. Not reactive policing, where almost people have to stumble upon something in order for a line then to be taken forward. And that requires leadership. It requires a political will to look at these issues properly, not scullying over them. And let's do something for victims around their mental health and well-being. Let's do something for them on pensions. The core issue is the sense of injustice that people feel within this society, that right has not been done. And they know that that may not result in people going before the courts and into prison, but they will not rest with any sense that the violence of the Troubles was in any way justified, because it was not. And this state must stand over that and provide for that apparatus.
Mary?
Yeah, thank you. Thanks for that. Just finally from me, I guess the government you've made very clear your views and your thoughts and wishes of the victims and your dissatisfaction with these new proposals. Why do you think the government has moved focus and changed its proposals?
Right, it's a good question, but I suppose in many ways, what have they changed to yet? We're not very clear on. And I suppose in many ways, some would use the terminology, was that 2-page document a fishing expedition? Throw out some terms and phraseologies which are departures from what's gone before to see where they would land in terms of thinking and reaction from groupings like ourselves. And the truth is, we're not going to give a really detailed view on those proposals until we see the content that exists behind them. Otherwise, in many ways, we're not doing our actual role or service to the victim survivors we represent. We want significant dialogue and an increase in that with the Northern Ireland office and with the UK government around these matters. See us as your partners in delivering this issue. Don't see us as the difficult children in the room screaming. We are part of your solution to get this issue resolved. You will not do it on your own, minus our involvement.
Okay, thank you.
Could I just ask, going back to the discussion we had about the analysis and investigation of armaments held, etc., and the point that you made very clearly with regards to the PSNI not being able to abdicate from one area of policing or another, would there be any merit in having another constabulary peer review and undertake investigations into the stash?
Thank you for that question again, Chair. And again, we would be open to a conversation around those matters. We do feel that the answers exist internally with policing, and there are enough mechanisms now to ensure proper oversight and independence of operations, if the will is there to find those. But if what
it's more that it it's actually more important that it is done and done properly rather than by whom it is done.
Well, certainly, but what our focus has been with that latest document is we believe that the competency does exist within the PSNI and LIB with a strengthened form to be able to do this. They can do so within a timely manner. They can do so in an achievable financial manner, and they can do so and start relatively quickly in all of this. If we are talking about building any external independent police force, because that's what it is, it will take years to get that off the ground to begin with, let alone then go through those cases one by one. It's just a non-entity. It's a nonsense.
Okay, thank you. We are just about to lose our broadcast slot. Can I, on behalf of the committee, thank you, Mr. Donaldson, Mr. Funston, and Ms. Gallagher for joining us, for your evidence before us this evening, this morning. Forgive me. If we have any further questions, then of course we can always communicate in writing with them. But thank you for your time. Thank you to my colleagues for joining us. I close the meeting. Order.
Thank you, Chair.